Good afternoon to all. A very warm welcome to Lawvs first National Moot Court Competition 2025. We are honored to have a learned judge, Rashi Agarwal, in this courtroom. We welcome your lordship. Before starting with the argument, we would like to brief the bench about the functioning of the courtroom. I, Deepal Goyal, will be serving you as court master and will be assisting you with maintaining the decorum and to assist the honorable bench. The court the court masters will act as facilitators between the bench and the counsel. The court master will time the arguments and intimate the bench accordingly. Your lordship is requested to please seek our assistance whenever it is required. As stated and rules of Lawvs first National Moot Court Competition 2025. Each team will get 25 minutes to present their case, including 5 minutes will be given for rebuttal and sub-rebuttal. Subject to the discretion of the Honorable Judge, each team shall initiate the court master in regard to division of time between speakers. Only one speaker from each team shall be permitted for rebuttal and sub-rebuttal. The order of presentation is petitioner speaker 1, petitioner speaker 2, respondent speaker 1, respondent speaker 2, rebuttal, petitioner, any one of two speakers, sub-rebuttal, respondent, any one of the two speakers. Where sub-rebuttal will be permitted only at the discretion of the judges. The judges may exercise discretion for extending the time for the oral rounds beyond the time specified in the rule book. The rule book provides the time extension up to 2 minutes is permissible for each round. The team code for the petitioner is team code 59 and the team code for respondent is team code 67. If time taken for rebuttal mentions that, ask it during before the commencement for the round. The total time is 50 minutes, with petitioner speaker 1 presenting their side for 10 minutes and speaker 2 for 10 minutes, whereas the respondent speaker 1 presenting their arguments for 10 minutes and speaker 2 for 10 minutes. And 5 minutes will be given for the rebuttal. I now would like to seek the permission of the bench to start with the proceeding.
Sure, please continue.
Thank you, Your Lordship, much obliged. I now request the petitioner to start with the proceedings.
Greetings, Honorable Bench. If it may please, for the sake of convenience, the Council seeks permission to address the bench individually as Your Honor and address collectively as Honorable Bench.
Yes, continue, please.
Much obliged. I'm Speaker number 1 and would be addressing issue number 1 and 2, and my co-counsel would be addressing issue number 3 and 4. We are from the side of petitioner.
Okay.
Much obliged. Council seek permission to state the jurisdiction.
Continue.
We have filed SLP under Article 136, and for the sake of Honorable Bench, I would like to continue with the statements of fact.
Please continue.
The Baki Bihari Temple in Vrindavan is a major pilgrimage site. Witnessed a fatal stampede in August 2022 due to overcrowding. The Allahabad High Court, exercising its power under 226 of the Constitution of India, directed the execution of 300 crore corridor. Also, the project was involving a large-scale demolitions and land acquisition. This project threatens the displacement of families, impacts the Vrindavan's heritage, allies, and risk due to Yamuna's floodplain. The challenges of the petitioner for the project before the Honorable High Court bench is the violation of Article 14, which is equality before law, Article 21, Article 25, Article 26, Article 300A, which is for the property, and the contravention of the following statutes, that is the Environment Protection Act of 1986, the Water Prevention and Control Act of Pollution Act, which is in 1974, the Ancient Monuments Act, the Right to Fair Compensation and Transparency and Land Acquisition Act. If the council is, if the Honorable Bench is well versed with the statements of fact, I would like to move forward to the issue number 1.
Yes.
Issue number one, whether the High Court's mandamus under Article 226 directing a particular corridor scheme amounts to an impermissible micromanagement of executive policy or is a constitutionally valid exercise remedy to systematic failure endangering life and safety. So, the jurisdiction under Article 226, we are mandating the execution of a selected Bake Bihari Hall corridor undertaking at the same time of human safety. The infrastructure technique development falls under the squarely in the domain of the government legislature, not just the judiciary, but it also violates the separation of powers, constitutes impermissible judicial overreach. Separation of powers requires judiciary to respective executive domains. Also, in the case of Asif Ahmed versus State of J&K, which is AIR 1989, it states that Allahabad High Court gave the judgment in the favor, which stated that the judiciary has crossed from the judicial review into the policy making, which violates the principle. And also, this is the strongest authority showing that a mandating specific corridor project under Article 226 is constitutional. And the subsection of B is judicial mandamus cannot replace legislative or executive policy. In the case of Common Cause versus Union of India, it is stated that direction must be stated in presence of absence of legislation. They cannot amount to a permanent policy making frameworks. Also, Supreme Court or any of the other courts or tribunals cannot make an order to the government to violate the statutory law of land. Also, it is stated as the ignorance of law. Mandamus is absolute abuse of power in this certain case, as it is a potent to be noted that it is not decided on the basis of facts, but it is decided on the basis of merits. Therefore, this has resulted into the violation of fundamental rights of citizens.
Counsel, I have a question for you. So you are telling the court that High Court does not has a wide power to issue writs for any other purpose, right?
No,
Then what do you have to say if the High Court mandamus is directing the specific corridor project, which is this beyond its jurisdiction?
no, it is not beyond its jurisdiction. It is within the jurisdiction. But the issue here is that the state of UP has not complied with EIA either, that is Environment Assessment, and has not gone through the statutory rules, has not got a clearance from NGT, and also they have not got Environmental Protection Act inconsistent of it. With also rehabilitation, fair compensation, they have not complied with them either. And issuing mandamus on such specific basis is unconstitutional because either court has the power that cannot violate the statutory law of land. It is a judicial overreach. This is the case of judicial overreach as far as the petitioner Govindas has stated.
Okay, go on.
Also, it is stated in Alembic Pharmaceuticals Limited versus Rohit Prajapati that it violates the basic fundamental tenets of the
Okay,
sustainable
counsel,
development.
quickly come to issue number 2, which you are dealing with.
Yes. Much obliged. Issue 2, which is whether reconfiguration of temples approaches allies and religious circulation routes implicate Article 25, which is freedom to practice, and Article 26, management of religious affairs. And if so, the correct test to distinguish faithful facilitation from unconstitutional interference.
Right.
Article in our constitution, Article 22, Article 25 and 26 is given to the citizens for their rights to freedom to profess any profession. While the state must justify such measures on the ground of crowd management and public safety, any intervention that alters the essential practices of religious practices, restrict ritual access, or interferes with the administration is unconstitutional. Also,
Where is it
essential.
given?
Yes.
Where is it given?
Under Article 25 and 26.
Okay, continue.
Essential religious practices cannot be diluted under Article 25 and 26. Any alteration of essential practices amounts to unconstitutional interference, as stated in the leading case law, which is Sri Venkateswara Swami Temple Protection Committee versus State of Andhra Pradesh, which states that The establishment of the religious roots, mostly linked to the temples, and are protected as the essential practices that cannot be lawfully altered by the state as well.
No, so council, do you agree that we still have the freedom to worship, right?
Sorry.
Do you agree that there's a freedom to worship
Yes,
given in
there's
the
a freedom.
constitution?
Yes, there's a
Then
freedom.
how does altering access routes or widening allies amount to violation of Article 25 and 26?
Because altering the main route of Vrindavan just to build a corridor which is for public safety amounts to interference. As in, if we look up to the route, there are many small temples which is given around the Vrindavan, which is given
On
around.
cost of human life.
No, not on the cost of human life, but as we have seen in Jagannath case as well, there were restrictions and restraint which was given, and the corridors were restrained to build, such that our case also falls under the same ambit to make sure that the restrictions and alternatives that have been provided in Jagannath case, that should be provided in this case as well. Because where Vrindavan is concerned, it is basically the city where Kunj Gali is celebrated. The main essence of spirituality also lies down between the same. So,
Okay.
maintaining a corridor and demolition of a lot of people and the livelihood under Article 21 would be restrained. Also, Article 21, which is life and liberty, also includes inherently that right to
Okay, I would
livelihood
like to
as well.
hear issue number 3 and 4 now.
My co-counsel would continue with issue 3 and 4.
Sure.
Greetings. I'll be addressing the issue number third and fourth now.
Please continue.
Yep. Issue number three states that whether the state objectives of crowd management and public safety, Article 21, justify large-scale demolition and redesign of an organically evolved sacred precinct with less restrictive alternative, that is, staggered darshan, tech-enabled flow, festival time regulation may exist. My argument would be the petitioner submits that while the public safety at the Baki Bihari temple is a vital under Article 21, the proposed corridor project is excessive by demolishing homes, altered sacred alley, and disregarding environmental heritage and property safeguard. It overlooks less intrusive alternatives such as staggered darshan and technology-based crowd control. The project thus threatens not only the safety but also the religious, cultural, and individual rights of the community. I would like to bifurcate my argument into four subsections, that four main arguments. First would be project without prior environment clearance are void under Article 21. As it is humbly submitted to the Honorable Court by the petitioner that the right of life under Article 21 of the Constitution of India includes the right to clean and safe environment. Development carried out without proper environment impact assessment, that is EIA, and clearance directly infringes this right. In the Albic Pharmaceutical Limited versus Rohit Prajapati, the Supreme Court held that the project operating without prior environmental clearance under the Environmental Protection Act 1986 are illegal and void. The court clarified that the post facto approval cannot legitimize unlawful activity.
Yes,
Similarly, in the
speaker,
Hanuman,
please quickly jump to issue number 4.
right, ma'am.
And I have two questions for you, and I'll continue this after you satisfy the code with issue number 4. Please continue.
Right, ma'am. Ma'am, in the fourth issue, it is humbly stated that the petitioner respectfully contended that the absence of meaningful public consultation is in the proposed Baki Bihari corridor project render the state decision-making process arbitrary. It is a utter violence of rule of law, violative to the Article 14 as well, and the contrary to the safeguard enshrined under the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. Here, the key stakeholder that will be affected by this particular corridor would be including approximately 200 families, 500 small enterprises, religious institutions, and environmental experts were neither adequately consulted nor properly rehabilitated. Such exclusion undermines the constitutional principle of transparency, fairness, and participatory governance, which is violative to the rule of law.
Right. So, counsel, I
Similarly,
have a
as in
very
the Law
small
Citizen Forum,
question.
ma'am.
I have a very
Yes, ma'am.
small question for you. I just want you to answer this one law point, that which specific legal provision was violated by proceeding against the environmental and heritage clearance? And is there any rules or any provisions that provide that if human life is getting lost in the process, then is there any shortcut process to get human environmental impact assessment done?
Um, Ma'am, sorry, honorable bench, I would the council seeks permission to address this particular topic issue for 2 or 3 minutes, and till then, can I continue with the issue number 3, because my co-councillor would get back to this research point, if it may please.
Okay, council, you can answer this after the another team arguments are done.
Right, ma'am. Thank you so much. Ma'am, I
Team,
have a closing statement. Can I
please,
give the closing statement?
sure, please continue.
Yes, thank you. Much obliged. If it may please the court, mandamus mandating a specific corridor scheme represent an unconstitutional judicial overreach violating the separation of power. While public safety is paramount, the state's salutation is disproportionate and arbitrary. Large-scale demolition, re-designing and sacred pertinent and altering essential religious practices violate Article 25 and 26, further infringes the right to life, Article 21, due to its lack of environmental and heritage clearance, as it is fundamentally arbitrary under Article 14, and the violation of property of rights under Article 300A. Having proceeded without meaningful public consultation, fair compensation, or rehabilitation for displaced families, we urge this honorable court to halt this unlawful execution action, set aside the honorable High Court's directive, and enforce the constitutional requirement for less restrictive alternative due process and stakeholder justice. If it may please, for the sake of convenience, the council seeks permission to address the prayer.
Your yes, council, continue, please.
Much obliged, ma'am. Honorable.
I have seen your prayer in your memorial. The other team can continue with the arguments, please.
Right, ma'am.
Team 67. Team 67, there's
Good
network.
afternoon, Your Ladyship.
Yes, there's a network issue on
Yes,
your
ma'am,
side.
there is
You can
network
switch off
issue.
your video.
Okay, ma'am. Good afternoon, Your Ladyship.
Good afternoon.
Council seeks
Yes.
permission to approach the dais.
Um, Council, there's no dais. Number one. Number two, are you the only speaker in this in your team?
Yes, ma'am.
Ma'am, as per the competition rule, it is important for the participants to turn on the video and see if that is possible.
Yes. Okay. Team 67, you can switch on your video. Okay, continue,
Your
please.
Ladyship, the council humbly seeks permission to begin.
Please begin.
Highly obliged, Your Ladyship. Your Ladyship, the council are appearing for the honorable in the matter of state of UP versus Govindas and others on behalf of the respondent.
Okay, continue.
The council humbly seeks permission to begin with statement of jurisdiction.
Yes, please continue.
Highly obliged, Your Ladyship. The respondents respectfully submit that this honorable court has jurisdiction under Article 32 of the Constitution of India, which guarantees the right to approach the Supreme Court for enforcement of fundamental rights. Article 32 explanation: according to the Indian Constitution of India, remedies for the enforcement of rights conferred by this part. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. Clause 2. The Supreme Court shall have power to issue directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this. Without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under Clause 2. According to Clause 4, the right guaranteed by this article shall not be suspended except as otherwise provided for by this Constitution. The Council humbly seeks permission to proceed with the statement of facts.
No, I know the facts. Please continue with your arguments. Please continue with your arguments.
Then the Council humbly seeks permission to proceed with the summary of arguments.
Yes, please.
With the issue number 1, highly obliged your ladyship. Issue number 1, whether the High Court's mandamus under Article 26 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy or is a constitutionally valid exercise to remedy systemic failure endangering life and safety. The respondent humbly respectfully submits that the Banki Bihari Vrindavan corridor project is constitutionally valid and necessary for safeguarding public safety and orderly worship at one of the India's most revered temples. In the aftermath of the 19th of August 2022 Banki Bihari tragedy, the High Court could have directed the state to prepare a safety plan and engaging expert committees and reports progress, thereby protecting the right to life under Article 21, applying the principle of proportionality. The project strikes a fair balance between individual rights and collective safety. Further, constitutional safeguards such as judicial review under Article 226 must remain supervisory, ensuring accountability without encroaching upon executive discretion, and that no arbitrariness is allowed in its execution. Therefore, the project harmonizes faith, safety, and constitutional governance, making it fully valid in law. Now, the Council humbly seeks permission to proceed with the argument advance of the issue number 1.
Continue.
Highly obliged, your ladyship. The respondent humbly submits that the High Court's intervention under Article 226 is not an impermissible intrusion into executive policy, but constitutionally justified exercise of its duty to protect fundamental rights. Where systemic inaction endangers life and safety, the court cannot remain a silent spectator. Article 226 of the Indian Constitution empower High Court to issue writs not only for enforcement of fundamental rights but also for any other purpose, making its ambit wider than Article 32. Judicial precedents affirm that when executive failure threatens Article 21, which talks about right to life, and the court's proactive role ensures constitutional governance. Thus, mandamus
Okay,
in
Council, I
the
have a question for you.
okay.
Would
Okay.
you, how many types of writs are there in Article 226?
There are 5 types of writ: mandamus, certiorari.
Then why mandamus? Why was mandamus filed in this particular case? It's okay.
Your
Continue.
ladyship, I will not mislead the court. At present, I don't have the exact answer, but I will be happy to clarify this at a later stage or in rebuttal.
Sure, you can continue with the second issue.
The council humbly seeks permission to proceed with the issue 2.
Please continue.
Highly obliged, your ladyship. On 19th of August 2022, during the auspicious festival of Janmashtami, a massive crowd of devotees assembled at the revered Banki Bihari temple in Vrindavan. The temple premises with narrow alleys dangerously congested. The influx of a high number of pilgrims in a single day overwhelmed the limited infrastructure, and in the ensuing chaos, a stampede occurred, tragically claiming two lives and injuring dozens more. This was mentioned in Moot proposition para number 12. The respondent, recognizing its constitutional duty under Article 21 to safeguard the lives of citizens, initiated a scheme to reconfigure temple approaches, widen alleys, and streamline circulation routes. Importantly, the respondent did not alter or interfere with aarti timings, darshan rituals, or bhajan practices, and so on. The
No,
intervention was
Council, I have a very small question for you in this issue that whether Article 25 does not prohibit interference with the essential religious practice. So, how is corridor justified? Because Article 25 prohibits the state to interfere in the religious practice, right? Essential religious practice.
I would like to answer this question with the case law.
Please continue.
Hindu religious endowments versus Shirur Murthy case, 1954 SCR 1005. The Supreme Court held that only essential religious practices are protected, while secular management of temples remains subject to regulation. According to the Article 25, we all have the right to freedom to profess, propagate, and promote any religion, but we have to keep in mind that it does not affect the people's public safety and morality.
Okay. Okay, continue with issue number 3.
Precedents uphold point 2 issue 2.2. Issue number 2.2. Precedents uphold state regulation of temple infrastructure. Indian jurisprudence consistently recognizes that temple infrastructure and assets management and secular matters within the state competence. In Sri Adi Vishweshwar versus State of UP 1997 4 SSC 606, restructuring of the Kashi Vishwanath temple was upheld because it did not interfere with worship but with facilitated it. In a certain case of Tilkyat Govind Lalji versus State of Rajasthan, the court observed that the temple management and associated property can be regulated for public benefit. As in the same case, in the case of Ismail Faruqi versus Union of India 1994 6 SCC 360. The court held that the right to worship does not extend to every physical feature of a shrine, as its roots are incidental, not essential. Point 2.3. The doctrine of proportionality justifies the scheme. In Modern Dental College versus State of MP 2016-7 SCC 353 requires that any restriction on fundamental rights must serve a legitimate aim, be suitable, minimally restrictive, and balance competing interests. In Acharya Jagdishwaranand Avadhut versus Commissioner of Police 1983 4 SCC 520. The court held that only essential practices are beyond regulations. As in the Indian Journal of Public Administration 2020 describes such crowd management in temples as enabling governance that strengthens rather than
Council,
weakens
clarify me
religious
one
freedom
thing
in
was environment impact assessment test was done in this case.
Your Ladyship, can you please repeat?
Was environment impact assessment test was done in this case?
No, Ladyship.
Then does not that make the whole process illegal?
The whole process is not considered illegal because the Baki Bihari Vrindavan Corridor project, the main aim of this project is to ensure public safety. This was mainly work for the widening the routes, alleys, so that the normal people and pilgrims does not want to face any sort of issue as according to the facts statement of facts in
Right, but
19th of
a
August.
construction that big also requires the consideration of the environment impact, right?
Yes, Ladish.
Then, if there's a involvement of environment in the matter, then environmental impact assessment, as per my knowledge, according to Environmental Act, is compulsory, right? Then, if the same was not done,
Yes, yes, sure, Ladish. But the main focus of this corridor project is to ensure the public safety. They did not recognize the environment impact assessment. They did not thought about the people who lost their lives. They have to
Who did
rehab
not thought? Who
the
is they
people,
in this
the people
situation?
around the temple.
So is it the duty of the temple and the people, or is it a duty of a state?
It is the duty of the
It's okay, take your time.
I did not at this moment. I did not structure my answer, Your Ladyship.
It's okay, continue.
Now the issue number 2.5, harmonizing articles 21, 25 and 26.
Sorry to disturb, but Team 67, your time has already ended. With judges' permission, you can request for more time, otherwise your time is ended.
Okay, I
Okay, ma'am.
think I'll stop with one question. What is 300A, Article 300A?
One minute. No person shall be deprived of his property save by the authority of law. This means that the right to property is no longer
Right.
a
So
fundamental right.
isn't isn't taking away the property without proper titles from the affected family
Your
is the
Ladyship,
breach of
could you please repeat?
sorry, isn't taking away the title from the affected family without the proper title deeds, right? Without the proper property titles. Is that not in contravention of Article 300A?
I would like to answer that right to acquire property without their consent is illegal. But according to the situation, the stampede and the stampede was occurred in Janmashtami, as we saw in the Mahakumbh also. There is a huge amount of pilgrims are combined together for practicing their religion, practicing their worship. But it so state try to acquire some property because they spend their 500 crore budget for expanding the corridor, or and the state does not want to, and the state does not want to waste their investment fund which they already spent. So I think that the state acquire the property for the public benefit, not for the own
Okay,
benefit.
okay. So I think we are done with the arguments from both sides.
So sorry, ma'am, to interrupt. I would like to answer the issue that you have raised in the round.
Yes, please continue.
Right, ma'am. Much obliged. Sorry. Hmm. To answer the issue raised by the honorable bench, the according to the statistics of India, the population and people of different religion in this country is around 140 crores. And
Right.
as population is increasing, we can't reduce the crowd everywhere, but we can manage the crowd by enforcing the existing laws and adopting the alternative, as we have similarly adopted in the Jagannath Puri case. Here, as answering to the issue raised, that there are there are existing a particular law. So to answer this question, I would like to state that there are various precedents to answer this particular, that they have established this particular law, which is Law Citizen Forum, Rural Litigation Case, Bombay Hawker Case, and various other cases such as various other acts such as ASI, Water Act, Environment Act 1986, LARR Act 1978.
Okay. Okay, very well, counsel. You have satisfied the
Sorry to
bench.
interrupt your ladyship.
Welcome.
There
Much
is
obliged,
one
ma'am.
more speaker from my team.
Ma'am rightly said, the state as a facilitator should have taken due consideration and would have taken the public consultation and complied with the EIA norms. It states the intention of the state that how they have act in the public safety and public welfare, because they have not consulted the stakeholder that would be affected
Okay,
by this
very well, very
particular
well. Both the councils
holiday.
have satisfied the
Much
bench. Now we
obliged.
may continue with the rebuttals, if
Much
any.
obliged.
I now request you to start with a rebuttal, and it will be for 5 minutes. The council permission. Start the rebuttal.
Please continue.
From the side of petition, we would not give any rebuttals against the defendant.
Okay.
Because we
Is
have
there any
received the,
rebuttal from the
Because the reason is because we have received the memorial in the short duration of time, and we cannot go through their facts and cases. But also, as the defendant has stated a case which is
the Joshi case, we would
case.
like to rebut that. My learned co-counsel has stated the Shirur Mutt case. I would like to rebut this case with the Joshi Mutt land substitutes, in which the politope principle and precautionary principle was established, and in which the court directed the NDMA and the state to rehabilitate resident and the stressed in a fragile zone. Precautionary principle must be strictly applied under Article 21, 48A, and 51A, subsection G. In the present case, even though Vrindavan is not identical to Joshimath, but it is ecologically fragile because of the Yamuna floodplains like Joshimath. Unplanned construction risk subsidize displacement and environmental collapse. The failure to adopt the precaution and carry out scientific studies before launching the corridor breaches constitutional duties. Here in Joshimath proved that unregulated development is a fragile zone lead to the irreversible damages. The petitioner can ask the Vrindavan must be treated with the same caution and construction halted until scientific clearances are secured.
Also, I would like to rebut on one issue, that is since a lot of many case laws and precedents have been set, the state of UP did not comply, as I have stated a lot of many times, and my co-counsel has also stated EIA norms. There's a case which is Alembic case, which states
I
that
think I'll give Team 67 the time to rebut now.
Much obliged.
Team 67 can continue with the rebuttals, if any.
I request Team 67 to please respond and start with the rebuttal. Am I audible, Team 67?
There is a network issue. Your Ladyship, I would like to answer this question with my speaker number 2.
I would like to answer the question of the streaming much case by saying that secular management of the temple precedents can be regulated by the state, and the project does not alter this ritual and core religious practice, only ensure public safety and accessibility on the basis of the incident which happened, in which the two lives we have lost, so that the state want to make the regulations in which it has been held that demolition is limited to narrow lines and unsafe structures. Devotees' worships, seva festivals remain enacted. In this case of Sri Muthu case, it was held that the corridor project is permissible by the state under Article 25 and 26 of the Constitution. You're not audible. Your audio is mute. Team number 59.
Okay, I think we can now wrap up the Moot Court competition. Both the teams.
Can I just take 20 seconds?
Ma'am, your Ladyship, can I counter one question from the petition side?
Please continue.
Can the petitioner explain how procedural objections should overweight the paramount right to life and safety under Article 21, when stampedes have already claimed lives?
when there is a honor killing of two persons and 25 people's injured. There is also, if we are considering the corridor to be built, there is a major reason of the principle, which is polluter pay principle and the precautionary principle, which states that constructing it, there would be debris, sewage, and a lot of many irreversible damage that would be occurred for the Yamuna River, as well as considering to the fact that the irreversible damage and also the livelihood of 200 more people would be destructed. This includes the Article 21, which you have stated, also includes right to life and liberty, but it inherently also includes right to life, right to livelihood, right to clean environment, and right to clean water as well.
Okay, I think I'll wrap up the mood code competition now. Moderator, is there any instructions? Moderator, is there any instructions?
Sorry, ma'am. Now the 5 minutes are over for rebuttal, and now I would like to request the Lordship to please provide the valuable feedback to the councils.
Okay, so councils, my feedback would be that you guys were very thorough with the research. That is the part I liked. But number one, so which year are you guys in?
PC 59 is from
Third year.
third year.
BLLB.
Third year. And
Yes.
67? Third year? Okay. So, my feedback number one would be please be very aware whether there's a bench, whether there's a single bench, a single person on the bench, whether there's a um, whether it's a two people bench, whether it's a three people bench. So you don't need to collectively answer, collectively address as the bench as your lordship or your ladyship, right? Because there's only me right now.
Right.
So, yes, be very careful about whether you address the bench as your lordship or your ladyship. So, these are the very basic things. Then, second, you can't approach the dais in the online moot court competition. So, that, like, I understand that you guys are nervous, but be little aware about these very basic things. Number three, don't read out what is the issue because okay, now I receive your memorials extremely late, but usually we do receive it a day before. So please don't read out the issues because that will waste your time of the arguments. Just just quickly jump onto the arguments. Start with the main point. Start with the punch, then you may continue with the extended arguments during the question answer rounds. But start with the punch, start with the main arguments. Um, of course, very basic things. Check your phone and your camera and mic before you join the meeting. And like keep on participating in these competitions, you will improve over time. That's it.
Thank you, ma'am.
And you guys can reach me out in to like you guys can reach me out on LinkedIn. My handle is you can search my name, Advocate Rashi Agarwal. And for any personal feedback, I am always available on LinkedIn. And whenever you are answering the questions, try and try to put the dots with your arguments so that your arguments make sense. Whatever you were arguing, try to put because as a judge what we try to do is that we try to ask questions out of the blue so that you guys get distracted, but bring back judge to the argument and try to join the dots. Okay, all the very best. You guys were very thorough with the research. Just whatever you guys must have read hundred of things while researching, now put them together in just 2 pages because the memorial part is now done. And both the memorials are very good. Just formatting was very good. T2067 formatting can be improved. um, T59 prayers do not need to be in bold. Okay. There is one blank page at the end of your PDF. So, very basic things, but
Actually, there was some technical issue in that
I get
laptop.
it. I get it. I get it. I've been through a law school myself, so I get it. I so
Some suggestion.
yes, please.
She's asking for some
Team could
suggestions.
Suggestions.
Yeah, she's asking for suggestions.
Suggestions as to what, like
Team number 67,
memo.
ma'am.
Team number 67 was asking
Hmm.
about it. I think her voice was
Memorial.
breaking.
The review of
She's
the memorial.
asking
The review of
suggestions
the
for the
memorial.
memorial.
Yes, yes, that's what I'm doing right now. So I liked your formatting. I appreciate it. Whenever you put a case law, put that in italics. The case laws are supposed to be in italics. Okay.
Okay.
And the versus V is supposed to be normal font, but the name of the case law is needs to be in italics, even when you are drafting in real life. So, like in real life, matlab, in practice.
Yes.
Okay. And yes, rest everything is fine. I like the formatting. And I will not get into the nitty gritties of the content because I've just received the memorials like you guys. But other than that, memorial looks good to me. It is well researched.
One thing we wanted to ask that while speaking throughout our arguments for the memorial and the same, were we fluent in speaking or do I know we need to improve about it, but I
No, you
wanted to
guys were
ask.
fluent. Like as I already given you the feedback that whenever you answer the judge,
Yes.
just try and bring the judge back to your arguments
Yes.
so that आपका भी flow break नहीं होगा, मेरा भी flow break नहीं होगा.
Yes.
And try and connect the dots with the so for example when you were arguing the first issue, I asked
Yes.
something connected to your third issue.
Third issue.
So
Yes.
whenever you answer such questions, mention it that your lordship, this the answer of this is also connected to my third issue,
Third issue.
and answer that during your third issue, so that number one, it will save time. Number two, it will like you will come across as a person who knows the argument. Okay.
Yes. And also, it's the first time when we are doing it virtually.
National
Yeah.
virtual
Oh.
moot court. We
Virtual
have done
moot
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 courts,
courts,
but
but
not the virtual moot.
Okay.
That's
Congratulations. Please continue
you,
doing
ma'am.
this.
Much obliged.
Okay.
Thank you, ma'am.
I would now request the participants to leave the meeting and would request the judges to please stay in the court.